Okay, and we're passing around a supplement to our materials. It actually goes at the very end. It's the foreclosure. I realized when I was going through this last night that there's not a lot today about the foreclosure process, and I thought, well, it would probably fit best within my topic area. So I kind of whipped something up this morning, so I hope it'll at least help you, steer you in the right direction if you need that. I know Marty Tucker needs a lot of expertise in foreclosure. Yes. So what I'm going to talk about today are post-default remedies for creditors, and whether or not you're the creditor's lawyer or the lender, a lot of these issues you're going to find once a loan has gone into default. And what you should consider when the loan comes into default. Your remedies are primarily governed by Article 9 of the UCC. The post-default remedies are in Section 6. I only have 45 minutes, and I could literally probably talk all day about these issues. So I've got a PowerPoint, kind of a brief summary. If any of you want a copy of my PowerPoint, email me. My email is at the front of your program with my little contact information, and I'm happy to send you a copy of that. So I won't go in verbatim and bore you to death and read all of this to you, but I'm going to try and summarize everything. The big topics are going to be an event of default, what is it, and what should you be looking for in your loan documents if one occurs, the non-judicial remedies that you have, which are quite popular these days, especially by some of the in-house counsel that I see here. And the judicial remedies are what we do when you hire one of us to take over the loan that's in default. So let's see if I can manage this here. So here we go. I've just mentioned it's governed primarily by Article 9 of the UCC, your collateral, whether or not you're dealing with any special assets or equipment. And then also we have Kentucky statutes. Rather than go through a listing of which ones are applicable, you can find several of them in my materials. But what I want to touch on today is the importance of your loan documents when there's a default. I learned very quickly in the start of my practice, when you're a new lawyer, you learn what the law is, and you have no expertise on real life experience of how you're going to apply that law. But I learned very quickly that you really need to read your loan documents before you do anything. As simple as that might sound, that is really where a lot of the litigation arises, is because of either something outside of the contract that occurred or some sort of ambiguity within your loan documents. So that is my starting point, is what actually triggered the loan of default, and how is event of default defined in your loan document, and also what kind of rights do your loan documents provide to you that may not otherwise be spelled out in the statutes or in Article 9. Are your loan documents cross-collateralized or cross-defaulted with other loans of the borrower? So those are provisions that you definitely want to look at and determine, are we dealing with a bigger problem, or are we dealing with one single loan and the collateral that was pledged to secure that loan? You really want to look at your fees and your acceleration of indebtedness, if there's a right to cure, if there is a notice and demand that is required. In Kentucky, we are not required by law to send a notice of default. However, almost all of our loan documents have one in there. And now, because of the changes that I've seen from 2006 especially to today in enforcement of loans, a lot of the lenders are going ahead and sending a notice of default to the borrower prior to it ever coming to me. So once I get it, even though the loan documents say that, I think it says something like, they can accelerate the indebtedness without notice or demand. That's the typical language. They still might go ahead and send a notice. Get a copy for your file, keep it handy. And secondly, if there is a requirement for a notice and demand and an opportunity for the borrower to cure the default, make sure that, especially if the lender did it, if there was in-house counsel that sent the notice or the special assets officer that sent the notice, make sure it's compliant with your loan documents. So I'm dealing with a pretty big foreclosure right now in Jefferson County, and the loan is 18 years long, and there's 10 amended restated documents and 5 modifications to mortgages, and there were the lender sent the notice and demand for 10 days of a right to cure, but I found 2 documents that had a 30-day right to cure. And I recommended to the client that we resend it and have a 30-day. And he's saying, well, and I said, well, it was never modified. And you would hate to come into a situation where there's a delay in your judicial enforcement simply because of the notice of default. And they do those. The defense lawyers out there will fight that the notice was not correct. So I always go on the side of caution and make sure that when you are sending a notice that it mirrors what is required out of the loan documents. Okay. And the acceleration of indebtedness, I do want to point out briefly, only because there was a slew of litigation, around 2010, that whole era, it seemed like, when the market crashed. A lot of the lender liability issues and even some of the changes in the regulations related to the counsel and lenders' requirements of notifying the borrowers on the front end of the loan at the time they initiate the loan and sign the loan documents, that of the bank's right to accelerate the loan. That they have the right to accelerate the loan, not just for a missed payment. You can't cure this by just curing the payment, but once it's accelerated, you're liable for the entire amount of the indebtedness. Make sure that's in your loan documents. Nowadays, it's a lot more prominent. But if I'm closing a loan, that's obviously something I point out to the borrower and or my client if I'm representing the borrower in a transaction. But on the back end too, it's always a clause in my complaint that we have the right to accelerate the entire indebtedness. Okay, so now I'm going to talk about the post-default. So you've determined what the event of default is. You know what your collateral is. You know what other triggers there might be in your deal. So now what is your best course of action? What should you do? A lot of this is going to depend. This is where the client ultimately, in my opinion, my lender has the ultimate say. And a lot of times, because judicial foreclosure has become so expensive for my clients, we do a lot of non-judicial remedies, or at least attempt them in the beginning. And those are the standard forbearance agreements and workouts and deeds in lieu of foreclosure. And then obviously there's a right to repossession and any of your Article 9 remedies to take possession of the collateral without filing suit. So I really want to touch on these, and I've got more details about what you should include in your forbearance agreement. A forbearance agreement, for those of you that don't know, is literally the lender's willingness to forbear from enforcement of the loan so long as the borrower will meet new conditions. And all those new terms are going to be spelled out in your forbearance agreement. It is not a new loan. That is the number one thing you want to avoid through this process. This is not, you don't want to get into a situation of novation. This is not new money. This is simply, and there is clearly sufficient consideration because the bank has agreed not to enforce the loan so long as the borrower meets these conditions, okay? So I have set out several terms that I'd like you to consider in your forbearance agreements, whether or not now, especially some banks are doing the forbearance agreements themselves before they obtain counsel, mainly because for an economic reason, and that obviously that's certainly fine. But look through these, and if you find a situation where you're wondering, what does she mean by, new money here? You want to clarify in your very first paragraphs of a forbearance agreement, you want the borrower to acknowledge the default, okay? You want the borrower to acknowledge the amount of the indebtedness that they owe, okay? Because you have to draft this document under the assumption that they're going to default on that too. I hate to say that, but you're drafting it that way, okay? We're paid to think of the absolute worst, and that's immediately what we think of. So think of it as whatever you need to protect yourself, okay? They're in default. They have to acknowledge that, and believe it or not, there's counsels for the borrowers that will say, we're not going to acknowledge the default. Nope, we're not going to do that. Well, then I would almost say that it's a done deal. We might as well file a lawsuit and litigate over that, because what else are you doing? Then you raise concerns that, well, this might be a new deal if they're not going to qualify that they have or acknowledge that they have defaulted on the loan. Why are we here? If you haven't defaulted, why aren't we just doing an amendment to your loan? So that is one of the most important, that this is not new money. You don't want to release any collateral unless you're doing it in exchange for some sort of payment, or it's part of the plan. This is the overall plan that you're going to put everything on pause, and the borrowers might have 3 months to sell ABC equipment, might have another 3 months to make a $500,000 payment here. But as soon as he defaults, and there might be a right to cure or something like that in your loan documents, then you have the right to enforce it however it's spelled out in the agreement, which is typically by a lawsuit. And then essentially your forbearance agreement becomes another piece of your evidence, so to speak, to prove your enforceability and entitlement to a judgment, okay, which is the overall goal here after default. The number one thing I would also, well, I guess maybe this is number two, it might be a tie here, but your release and waiver provisions. Actually, I want to say, the first few forbearance agreements I was doing, the release and waiver wasn't as big of a deal. I wouldn't say as big of a deal, but now when I mean big deal, I mean we have it in bold, all caps, black font, different font, that they are releasing the bank of all liability. And they will not sue the bank. They will not contest the default. Put it in big, black, bold letters, just like you would for a jury waiver provision in some of your loan documents, that this is a condition for the bank to do this. The bank would not do this without a release, okay? And you obviously have sufficient consideration for this. There was a lot of litigation, and some of it's still going on, about release language. And once you go in and file the action to enforce the loan and the forbearance agreement, they're saying, well, we didn't have a lawyer. We just signed it because we had no choice. That release language was in fine print. It looked like all the other stuff. How was I supposed to read 25 pages that this lawyer drafted? So that's why we put it big, black, bold letters, okay? And we've won some summary judgments on those, so I would definitely, that which ties with the number 1 on your default provisions, and that this is not a new loan. I hope the cartoons aren't too, there were only so many clip arts I could find for loan documents and defaults and stuff. Okay, so your forbearance agreements, deeds in lieu of foreclosure. I think we're all probably familiar with these, and they're certainly a lot more popular, especially when the value of your property is a lot less, okay? They may not be as popular when there's a lot of liens on the property, because a deed in lieu of foreclosure is essentially handing over the keys, handing over title, but you're going to take it subject to everything that's on the property. So you want to make sure you have triple checked your title before you do this as a creditor, and you want to make sure that you're willing to pay any delinquent taxes that are due. You're willing to pay a mechanic's lien that may be there. If you're not willing to do that, or if there's a second mortgage that you're not willing to pay, that's when you need to go into the judicial remedy. And I don't know if I put it on the slide here. Oh, here we go. So I don't know if side agreement is a legal term or any like real term. That's just what I call it. So I use a deed in lieu with a side agreement. And my side agreement is an agreement where the parties understand what we're doing. Okay? You exchange when you get your keys, you get your deed in lieu, you've done all your due diligence, but then what? So you take your property and the debt's $200,000 and you sell it for $150,000. Well, I bet you anything, without some side agreement that says how you're gonna determine that deficiency, the borrower probably thinks they're off free and clear. And then when you go file suit without some side agreement telling you what's gonna happen with the deficiency, they're gonna say, well, I gave them the house. I didn't know. So I always recommend, and it doesn't have to be as long as a forbearance agreement, but I certainly would include a lot of the same terms that you would in your forbearance agreement. But the key difference in a side agreement is it spells out your deed in lieu and what you're doing. And then it also explains what you're going to do with the deficiency. Is the deal, look, we're done arguing, we're done dealing with the borrower on what's going to happen here and there, and economically it makes more sense for the client to take a deed in lieu and waive the deficiency balance. So I always say we can do a side agreement and waive the deficiency balance, or a side agreement and we're not going to waive the deficiency balance. Okay? That's essentially what the side agreement is to me. And with your side agreement, you can get really creative. And that's how I can get a lot of deals cut. Meaning, well, the bank says we've had an appraisal here, we think, which is a lot lower than the debt, which is very common when you're in this situation. And we're hinging on this waiving a deficiency. You know, I don't know if we can do this. Well, okay, if we think the deficiency is going to be $500,000 based on our appraisal and the debt amount, why don't we cut it in half? To get the deal done, why don't we cut it in half and do a cap? We're going to cap the deficiency at $250,000. Okay? So if the deficiency is $300,000, borrower, we would only enforce it up to $250,000. Those are the terms that you would want to put in your side agreement. Okay? Does that make sense? Yes? Okay. I have a few other provisions in here. Merger, definitely, and any personal property issues. Believe it or not, you know, we've had that with personal property issues. That's why I threw that in there. I've had 2 cases recently where we did a deed in lieu and they left all this stuff and then claimed that we converted it later. So I now put that in my side agreement. Okay, I've got deeds in lieu. There's my bold and capital letters. Okay, another non-judicial remedies, repossession. Okay, this obviously is a lot more popular with vehicles. Okay, but you know, we also do it with equipment. I've done it with airplanes, boats. Those are the fun ones, I say, for me. So, and you have all types of different perfection issues and so forth. But I think repossession is a remedy that can save your client money without having to go and file a lawsuit. And I know you're hesitant because you're going, how can we do all, you know, how are we going to do that? You know, if you're not breaching the peace and you're following Article 9 to a T, you can do it. If your loan documents say that you have the right upon an event of default and one of your remedies is to go onto the property, to take possession of the collateral, to sell the collateral and apply it to the loan balance, you have the right as a secured creditor, and you're properly perfected, you have the right as a secured creditor to do that without filing a lawsuit. And we don't just have to do it with cars. So, but if you do file the lawsuit and obtain the judgment, there's a lot of other creative ways you can go about to protect yourself. You may not want to repossess if it's a special situation. You know, this is when you go into the drive-by situation. Evaluate your property before you do something like this. I put the breach of the peace in here just because I think a lot of creditors forget about that sometimes, and think that it's, you know, because of TV shows and so forth, it's only related to storage facilities or vehicles. But you do have the right with other, especially here in Kentucky when we have a lot of ag equipment, you know what your loan documents say and know what your rights are as a secured creditor to go get it. That's why those provisions were created in Kentucky, and that is why we incorporated them in your loan documents to begin with. Let's see. Okay, what do I have in here? Oh, there is a, in Kentucky, the law is split, and I think I do have it in my materials in more details on, I had a case recently about a big farm truck, and it was in a open garage, like one of those sheds at the farm, and whether or not they could go into the property and take the truck from the garage. And in Kentucky, if it's open, you actually can, okay? And other jurisdictions are split. But, you can't go peeking around and, on TV, I know that's a lot of drama and stuff when they do all that kind of stuff, but you can go in and take possession of your truck on the property, okay? Now, when you get into attached garages and all that, I have 15 minutes. Just be cognizant of that. But a lot of times, borrowers will purposely put it in the garage because they think you can't. But here you can. So I did throw that in there. Okay, judicial remedies. if I were to go down a list of what your judicial remedies are, okay? So now you've tried everything, you're fed up, they're not cooperating, they've defaulted again on a forbearance agreement, and as a creditor, I'm not trying to bash any debtor lawyers here. I know I see a few, but this is on creditors' rights. So, but they're not cooperating, and the only choice you have, there's lots of, there's no equity in the property. There's, you're dealing with a slew of liens on the property. You need to take an alternative measure, okay? You've hired counsel, and you're gonna take the approach of actually filing your lawsuit. For foreclosure, and that's what the handout is, but for a foreclosure, the number one thing that I've learned in the state of Kentucky with 120 counties is to know your local rules and know what that master commissioner does. Just when I think I know what Jefferson County does, they change something, and Edith changes something. But know your local rules, because it's gonna delay. So be prepared. But if I were to make a short list of all your judicial remedies, they would be writ of possession, attachment, injunctive relief, foreclosure, and then you have your post-judgment collections. Those would be the most popular, I would say, and the most widely used and most beneficial and economic for the client. Writ of possession and TROs, that's governed by Chapter 425. I do a lot of writ of possessions, and you have to follow the statute to a T. Even though I've done a ton of them, I still make sure you're compliant with the statute. So the lawyers out there doing writ of possessions, follow the statute to a T. And you will think, I've already done this. This is redundant. The notice and demand and this and this. No, you have to do it to a T. But a writ of possession is basically a prejudgment writ. So you have, and they're very useful, especially when I've got a situation where the borrower is still using my collateral, my equipment, and we want to stop that. Or we're worried he's going to sell it or move it, or the equipment is movable. Go through the process, and I like to do it as soon as I file the complaint. If I'm unsure, if my client says, well, I'm not sure we're going to do a writ, he's doing this, and he's doing this with the collateral, we haven't been able to locate it, I might include it as a count in my complaint, because you have a certain amount of time after you file your complaint to file for your verified motion for writ. So, but I like to do it simultaneously, and I have the clerk file the complaint, you file your notice and demand, and you follow exactly to a T, and have the sheriff go out and levy, and et cetera, et cetera. Injunctive relief, permanent and temporary restraining order, depending on what your circumstances are. Those are definitely available and useful. They are fast moving, as the lawyers know, and they do require a lot of work, but sometimes it's what you need to do to shut down a business, or it's something you need to do to prevent the borrower from doing anything else or jeopardizing your collateral. Okay, I'll talk the last bit just about foreclosure and the post-judgment remedies. Did I have? Okay, there it is. Okay, foreclosure. I'm not going to talk, I don't do a lot of consumer work, which is obviously to be compliant with FDCPA regulations. I do some residential consumer work, but mainly commercial foreclosures and businesses. And so that's primarily, but the one thing I can say about the consumer is just make sure you have the correct notice. and ensure that you have your long notice, and then you utilize your short notice, because there's a slew of lawyers out there. There's like 3 of them. I'm constantly seeing them filing lawsuits for violations of the Fair Debt Credit Practices Act. And that is the one kicker right there on your notices for residential and your filing of actions, and then continuing to at least use your short notice in all subsequent pleadings and notices, so that you don't get hit with that. So anyway, commercial foreclosures, again, I mentioned, know your master commissioner rules, know what they require. If they require fees up front, if they require certain forms to be used, I mean, I love it when they say, we have a template judgment, use this template judgment, because otherwise you're back and forth and back and forth and back and forth with the master commissioner, and it's delay, which is not what I like telling the bank, is that I'm being delayed because the master commissioner is requiring something else. But before you can even file your judgment, if you look at the little handout I gave you, I went through several what I called considerations before you even file your foreclosure. Obviously, you're past the pre-judgment remedy stage now. The simple things of a checklist. I kind of thought of everything I might do at the beginning of the case. Order your title exam, and make sure you trust your title examiner. And especially in some of the outlying counties, make sure you trust that title examiner, and get copies of all your encumbrances, get copies of all your tax liens. I now have a best practices just from my own experiences. I always name whether it's county, city, urban, whatever, depending on the 120 county I'm filing the lawsuit in. But I name the county or I name the city out of an abundance of caution, because sometimes the foreclosure may take forever, and it may not be due and payable at the time you file your lawsuit, but it might be, the taxes may be due and payable by the time you sell. Or they may file bankruptcy in between your lawsuit, and you're a year and a half delayed now, and not only were they weren't due and payable at the time you file your foreclosure, but now they've been sold because it's been over a year. They're a year delinquent, and they've been put on the market, so to speak, and they've been sold to a third party who failed to file an assignment with the county clerk, which is very common, but they still have an interest in the property. So long, and I've taken this up to the Court of Appeals, so long as you have named your county in the lawsuit and you have filed your lis pendens with the county clerk, you are probably okay? So those are the number one things. Update your title, update, okay? Especially if it's gone on and on and on and on. And even if the lis pendens statute, I don't want to get off on some tangent here, but the lis pendens statute is there to protect us, the banks. And it's there to protect us, to put everyone else on notice that there is a pending foreclosure. And even though it is not up to us to name them in the lawsuit after the lis pendens is filed, it can generate a lot of, there can be a lot of litigation. I've had an appeal over it, where I was trying to get the Kentucky Bankers Association involved because they were trying to change the lis pendens statute and make it a requirement that we had to update the title the day of the sale. So that's neither here nor there. That didn't happen. But your lis pendens and updating your title, looking at your property description, ensuring that the property that your borrower has pledged as collateral for the loan is actually the same property that they own. Okay, don't just copy the property description in the mortgage. You don't learn that until you've made a mistake. But so always check your property descriptions from your deeds and your mortgage. And if you notice that the deed and mortgage, and you look at a plat, especially huge commercial properties with easements here and right-of-ways here, and they consolidated and did all this, that oops, it doesn't look like they have a portion of the property. You may want to fix that before you file a lawsuit. Let's see. Identify your parties. Make sure you have your unknown tenants. Make sure you have your unknown spouses. Make sure you have your unknown estates if they've died but not opened an estate, to where you're having your warning order attorneys. If there's a homeowners association, make sure you name them, because they actually, by law, have an interest in the property. So they need to be in the lawsuit, and there may be assessments that are due and payable. And then just some safety issues, I could say safety and maintenance issues, to make sure that the property is maintained. Has it been abandoned? What do you need to do? Things you need to advise your client, okay? They may be new. Don't assume that your client knows that we need to secure the property. You know, don't assume that your client knows that, we need to make sure that there's still insurance on the property, because the foreclosure process can be lengthy, especially if there's a lot of parties involved, and especially if there's potential claims. So, and a lot of that carries over into what you need to include in your foreclosure complaint, and I've included that in there. In Fayette County, the judicial foreclosure, the numbers, we've dropped 30% from last year in how many foreclosures we're actually filing in Fayette County. And at the sale last week, there were 28 properties that were sold, and only 5 of them were bought back by banks. So the rest were actually purchased by third parties. So that's great for the bank, because they're for once, we're not buying them back all the time. But it just goes to show too that there's not, because how the 2008, 2009, when there weren't as many homes being built, if you think big picture, there's not a lot of inventory out there right now. So they're buying them at foreclosures, which is beneficial. So I say that because that's something to consider if you're debating on whether or not to file a foreclosure today. You might, depending on the property, it might be sold to a third party. And I love sending the client a check, and the money's dispersed, and I love sending that money, and not just another bill to pay the master commissioner's fees. So, now even in Fayette County, we're having a hard time even filling up a full sale date. There's so few foreclosures here today. And a lot of it's because we're also doing these non-judicial remedies, but it's also because the rates of foreclosures have dropped. And whether or not it's the lenders doing more workouts, or we're seeing the effects of 2008, I don't know. I think maybe in a couple years we'll see how this is all going to play out. I also just included, the standard provisions. I cited to a lot of the statutes. I literally kind of threw this together. I think my law is correct on here on the statutes. But just the process you need to go through in the checklist. Sorry, Kevin, if I wasn't supposed to say that, but it's correct. So I don't know if y'all do have any questions. Let's see if there's, I did the personal property execution. I know my time's out, but don't forget about that in Kentucky, that once you obtain a judgment and you've sold your collateral and there's a deficiency, you can still go back and execute on that. You can meaning you can execute on the borrower's personal property whether or not you have a security interest. And, call it what it is, but you can go to the person's house and do an inventory on the collateral in the house and sell it at a sale to recover your judgment, depending on the circumstances. I've had moving trucks. You have these. There's a reason. So you can fight for your client and you can obtain as much money as you can to recover and make them whole here. And then there's the charging orders, which, I don't know, in Kentucky, I don't do very many of those because our judges don't seem to understand them all the time. But anyway, if you have any questions, email me. Or if you want a copy of the materials, everything's in the materials that's on the PowerPoint. But feel free to just ask anytime, and I'm happy to share. So thank you so much. I think I went over a little bit. Sorry, Kent.